Concept of law affecting employment in tourism and hospitality. This is part 2, and we are going to talk about labor relations. When we speak of labor relations, laws intended to stabilize the relations of employees and their employers, adjust differences between them through collective bargaining, settle labor disputes through conciliation, mediation, and arbitration. So itong mga batas na ito, class, is intended para maging maayos ang relasyon ng employee at employer. At kung meron mang mga dapat ayusin, ito ay aayusin sa pamamagitan ng ating collective bargaining agreement, yung CBA na tinatawag, or kung meron mang labor disputes na kung kinakailangan ng conciliation, mediation, and arbitration. This is a little technical class, but I'm going to discuss this ng bullet lang, yung pinaka-importante lang para mas maintindihan nyo pag kayo ay nagtrabaho na at naisipan yung ano ba ang pwede nyong gawin para yung differences ng employer nyo sa inyo ay maayos. So basically, with the definition, through conciliation, mediation, and arbitration. Pero kung meron kayong collective bargaining agreement, pwedeng maayos doon kahit na yung labor dispute nyo. Okay? So ano ba talaga ang tinatawag nating labor relations? Una, class, you have to understand that you have the right to self-organization. Ano ba ang ibig sabihin ng labor, ng right to self-organization? Ito yung pagkasama-sama ng mga empleyado na pare-parehong antas ng pagtatrabaho. Okay? Ito yung polisiya ng state. It is the policy of the state to promote the free and responsible exercise of the right to self-organization through the establishment of a simplified mechanism for the speedy registration of labor unions and workers association and determination of representation. Hindi ka lang basta-basta nagtatayo ng union. Dapat malaman kung sino ba talaga ang representative ng kumpanya or ng employee para sa isang kumpanya. Okay? Class, now, simplify natin. So, pag naisipan na ng isang o ng grupo ng empleyado na magtayo ng union o asosasyon ng mga empleyado, ang tatawag na dito ay labor organization. Ang labor organizations, class, ay magpa-file sa regional office kung saan man yung principal office nakalocate. Okay? Ito yung sa Labor Relation Division. Sinisimplihan ko lang, class, ha? Remember, magtatayo kayo ng association or ng union doon sa lugar kung nasaan ang principal office. Kung maraming opisina o maraming kumpanya ang maraming sangay ang isang kumpanya. And that is the labor organization na tinatawag natin. Merong mga requirements yan. Very clear ang batas. Under Rule 3, Section 2, the name of the applicant labor union, the minutes of the organizational meeting, the name of all its members, comprising at least 20% of the employees in a bargaining unit, at kung meron silang annual financial reports at applicant's constitution and bylaws. Okay? So yun, class, ang importante. Now, meron tayong class na tinatawag na voluntary recognition. Ano yung tinatawag? Kasi, class, remember, hindi naman lahat nagkakaintindihan kung paano kung isa lang ang nag-apply. Okay? Again, sabi ng ating konstitusyon, Section 1 ng Rule 4 ng ating Labor Code, it is the policy of the state to promote free trade unionism through expeditious procedure governing the choice of an exclusive bargaining unit. So, dapat merong pipiliin. Kung merong ginawang asosasyon o union, dapat i-recognize to. I-recognize ng ating kumpanya because the determination of such exclusive bargaining agent is a non-litigious proceeding. Ibig sabihin, walang litigation kung sino. Pwedeng ang tinatawag natin na voluntary. Yan yung number 3 dyan sa ating slide. Voluntary recognition. Ang sinasabi rito, class, in an organized establishments with only one legitimate labor organization, the employer may voluntarily recognize the representation status of such union. Within 30 days from such recognition, the employer and union shall submit a notice of voluntary recognition with the regional office which issued the recognized labor union certificate of registration or certificate of creation of a chartered local. Ang ibig sabihin, class, sa isang unorganized, pwede. Ibig sabihin ng unorganized establishment, class, wala pa silang labor union. So sa isang wala pang labor union, pwede lang mag-submit ang isang asosasyon and yung kanyang employer will recognize the such representation. Within 30 days naman, dapat mag-submit sila ng notice of voluntary recognition. Okay? O so ngayon, sir, paano yan? Paano yan pag dalawa or more ang ating association? Anong gagawin? Ang gagawin naman doon, class, is the certification election. Okay? Sino magka-file? Any legitimate labor organization may file a petition for certification election. Okay? So, the petition must be heard and resolved by the med arbiter. So, sasubmit nyo sa regional office, tapos sasabihin nyo, paano yan? Gusto namin magkaroon ng certification election para kung sino talaga ang i-recognize. Okay? I-recognize ng company as the labor union or association ng kumpanya. Okay? So, yun lang yung ibig sabihin ng certification election. Okay? Next. Ano yung tinatawag nating grievance, machinery, and voluntary arbitration? Okay? Kasi, class, it is very important na meron tayong grievance machinery or voluntary arbitration doon sa tinatawag nating collective bargaining agreement. Remember, sa definition, dapat merong collective bargaining agreement. Doon yung kayo magsasabi kung anong kailangan nating ayusin, kung anong problema ng asosasyon. So, pag nanalo sa certification election or voluntary recognition ng isang union, pag nagkaroon sila ng discussion with the employer, kasama doon ang tinatawag nating grievance and voluntary arbitration. Okay? So ano dapat? Ano dapat ang nakalagay sa grievance and voluntary machinery or arbitration? Okay? Dito, class, sinasabi lang naman dito na ano ba yung pwede. Okay? Pag nagkaroon ng isang pagtutunggali ang isang employer at employee, okay, there should be an establishment of grievance machinery. The parties to a collective bargaining agreement shall establish a machinery for the expeditious resolution of grievances. Dapat may machinery para sa mas mapadali na resolution kung meron mang grievances arising from, ano yun? Ano yung madalas? Interpretation or implementation of the collective bargaining agreement, and those arising from the interpretation or enforcement of company personnel policies. Okay? Una, interpretation and implementation of the collective bargaining agreement or interpretation or enforcement of company personnel policies. Last, unresolved grievances will be referred to voluntary arbitration. For this purpose, parties to a collective bargaining agreement shall name and designate in advance a voluntary arbitrator or panel of voluntary arbitrators, preferably from the listing of qualified voluntary arbitrators duly accredited by the board. Ganun lang yun. Kung hindi mare-resolve ang anumang grievances, class, Okay? Magre-refer tayo sa voluntary arbitration. Okay? Kaya ganun ka-importante ang grievance machinery at ang voluntary arbitration ng isang kumpanya. Now, gusto ko lang i-mention dito. I want to make mention conciliation, strikes, and lockouts. Para ito kasi yung mga common na nakikita nyo. At ano ba ang differences? Ano ba ang talagang ginagawa sa mga bagay na ito? Okay? When you speak of conciliation of labor management disputes, the board may, upon request of either both parties or upon its own initiative, ibig sabihin pag sinabi niyong both parties, employer and employee, provide a conciliation mediation services to labor disputes other than notices of strikes or lockouts. Conciliation cases which are not subject of notices of strike and or lockout shall be docketed as preventive mediation contests or cases. Ibig sabihin, class, una, kailangan munang ayusin through a conciliation mediation services na ang miyembro ay both employer and employee. Pipiliting ayusin, class. Okay? Parati yan. Okay? The law may tilt in the favor of labor, but it is always the objective of the law is para maayos parati and avoid strikes and lockouts. Okay? Yan ang parating iisipin nyo. Ayusin muna natin, i-try nating mag-ayos. Pilitin nating mag-ayos. Otherwise, that's the only time papayagan ang strikes or lockouts. Ano ba ang grounds for strike or lockout? A strike or lockout may be declared in cases of bargaining deadlocks or unfair labor practices. So dalawa ang pwedeng dahilan kung bakit kayo mag-strike. Merong deadlock sa CBA or collective bargaining agreement or unfair labor practices. Violations of collective bargaining agreements except flagrant and or malicious refusal to comply with its economic provision shall not be considered unfair labor practice and shall not be strikeable. Pag yung may malicious refusal to comply, hindi siya considered na unfair, so hindi siya pwedeng mag-strike. Ano pa? No strike or lockout may be declared on grounds involving inter-union or intra-union disputes. So pag nagtatalo ang mga union sa loob ng kanilang asosasyon, hindi siya pwedeng mag-strike or mag-lockout. Okay? Hindi rin pwede na strike will be declared after the assumption of jurisdiction by the Secretary after certification or submission of the dispute to compulsory or voluntary arbitration or during the pendency of cases involving the same grounds for strike or lockout. Plus, tandaan nyo itong part na to. Pag may mga sitwasyon kasi or merong mga instances wherein hindi basta-basta nag-strike ang isang kumpanya, lalo na kung ito ay hinawakan na ng Department of Labor. Dahil pag ang Department of Labor, alam nyo namang yan ang sekretary ng ating presidente. At pag hinawakan na yan, ibig sabihin of paramount interest ang isang kaso. Kaya hindi na pwedeng mag-strike. Back to work at ang magre-resolba niyan ay ang gobyerno. Ano yung example dyan? Hospital class. Hospital. Even schools class. Ito yung mga bagay na binibigyan ng paramount importance because hindi ka pwedeng mag-strike dahil hospital yan because you're dealing with health. And school kasi yung mga estudyante. Minsan nga kasama pa rito class ang gasolina. Yan ang mga bagay na iniiwasan ng ating gobyerno kasi it will cause economic instability. Kaya hanggat maaari, iwasan ang ating strikes or lockout. Meron tayo class, hindi ko lang naisama dyan yung tinatawag na peaceful picketing. Itong peaceful picketing, isa rin to sa paraan upang marinig ang boses ng mga empleyado. Here, workers shall have the right to a peaceful picketing because no person engaged in picketing shall commit any act of violence, coercion, or intimidation or obstruct the free ingress or egress from the employer's premises for lawful purposes or obstruct public thoroughfares. No person shall obstruct, impede, or interfere by force, violence, coercion, threats, or intimidation. Any peaceful picketing or by workers during any labor controversy or in the exercise of self-organization or collective bargaining or shall aid or abet such obstruction or interference. No employer shall use or employ any person to commit such acts, nor shall any person be employed for such purpose. Okay? Peaceful picketing ang pinag-uusapan. So, inaalaw yan, class. So, walang violence, walang threat. Kasi, syempre, it will cause obstruction. Bawal harangan ang dinadaanan at ang ini-exitan ng mga empleyado. Okay? So, that is employment. Okay? Laws affecting employment in terms of tourism and hospitality. Hindi naman siya isolated lang class sa hospitality and tourism because that is in general. Para lang maintindihan nyo pag kayo ay naging empleyado na ng hotels and restaurants. Okay? So, that concedes our topic regarding employment. So, I hope may natutunan kayo kahit paano. Stay safe.